It is 9:16. Welcome back. Jeffrey Epstein's former girlfriend, Ghislaine Maxwell, is working to keep grand jury records secret in the sex trafficking case that sent her to prison. This comes as prosecutors are urging a court to release some of those records. Her attorneys say that Maxwell has not actually seen the material, but she opposes unsealing what her lawyers described as potentially hearsay-laden transcripts of grand jury testimony.
Now, if the case isn't complicated enough, the House Oversight Committee subpoenaed the Justice Department on Tuesday for files in the Jeffrey Epstein sex trafficking investigation because they're seeking depositions with the Clintons and former law enforcement officials as part of a congressional probe that lawmakers believe may show links to President Donald Trump and former top officials.
All right, bringing back our chief legal analyst, Khalif Rhodes. Khalif, as one person, I need you to defend both sides here. What's the good and the bad about unsealing these transcripts here?
Everything is bad about this entire process, and so I like the way you proposed that question for a number of reasons. This whole Epstein thing, what's lost is that there were a number of real victims there. So I first want to start there. Maxwell was convicted 5 times, 5 counts of real crimes against real individuals. Conspiracy to entice minors to travel to engage in illegal sex activities, enticing minors to travel, sex trafficking of a minor, transportation of a minor, conspiracy to commit sex trafficking. These are all real charges with real victims. And while folks want to see the tapes and want to see lists, and I know we have a fascination with like these true crime dramas, what I want people to remember is that there were true victims to this, and this woman right here that's now trying to appeal her convictions was convicted and now is trying to find a way out of this. In terms of the playing both sides of the grand jury, I can say a few things. The grand jury is not a real full-fledged trial. It's a grand jury hearing that is with the prosecutor, with the grand jury. No defense is present, no defense attorney is present, and the key portion is the rules of evidence don't apply. That's crucial because the rules of evidence keep things fair in the courtroom. If the judges always say calls balls and strikes, my job as a defense attorney is to hold both the judge and the prosecutor accountable. If the rules of evidence require that you're supposed to do things a certain way and the judge is not holding them accountable, I'll make an objection. Why am I making that objection? So that once I appeal, I can say, hey, it's on the record that I appealed, the judge didn't follow the rules, next court overturned their wrongful error. Well, in this situation, when you have a grand jury testimony and hearsay evidence is coming in, things that would never get into court. I tell Julian something, Julian now goes in front of the grand jury and testifies against it. Well, he testifies about it. He can't do that in a normal trial. I'd stand up and object because it's hearsay, and instantly his testimony would be removed. And so that portion may have been great to hear in the grand jury, in a real trial would be excluded. So her team is not wanting that to happen because the first portion is most of the things that happen in there wouldn't have happened in the real trial. Second portion, her team hasn't even been able to hear the information. They don't know what took place in the grand jury. Most of my clients are indicted on grand jury, and I've never seen the grand jury information that happened in that room. And so her team is like, your only thing that can happen from you releasing this is hurting my clients' potential appeals that are out there right now pending.
I do have some questions on some of the reported redactions that we've seen in the quote-unquote Epstein files, but I do want to ask first, as far as Ghislaine's team, though, what legal right do they have to ask for this to not be released? I understand the victim saying we don't want this stuff out there, but what right does Ghislaine and her team have to say we don't want this out?
I mean, the argument made is clear that this is going to be more prejudicial than probative. That would be the argument that I would make on excluding or not allowing evidence to come into my trial. That's what I would argue here. Your Honor, I have a pending trial. I have an appeal that's before the court, 2 different courts. And because I have a case that's appealed in 2 different courts, any evidence that was submitted or released to the grand jury or provided to the grand jury, that evidence that didn't fall under the rules of evidence could hurt me going forward. Because it's more prejudicial than probative, I don't think it should be released, and if it is released, I would ask in the alternative, if the court agrees that this should be released, Your Honor, release it after my appeals have been, completed, but not before, so let's to prejudice me. Now the court is put in a position to say, I have 2 options. I have an opportunity to release this now and hurt this person, hurt their appeal, or release it later and still give the public what they want. So there's 2 opportunities here for a judge to go that route, and that's what I would argue if I'm the defense. On the other side, to Jason's original point, they asked for these things to be sealed. This grand jury testimony when the U.S. attorneys were arguing this case originally. So now you're going back and saying, look, we want this to be released. That argument can be either accepted by the judge, but they're going to have to say why. Why did you want them sealed originally? Why would you not want these to be out? And now why should I release these now? That's how we get to that answer, and the judge has to do that balancing test. They're, again, calling balls and strikes all day.
With your crystal ball, Khalif, looking, I don't know, 6 months, a year ahead at all of this, right? Whether it's the Epstein files, the grand jury transcripts, where do you see this going?
I mean, if I'm Maxwell, if I'm representing her, I'm trying to negotiate my client in front of Congress to get her, you know, some type of clemency for the things that she was convicted of. I mean, that's all she has, because she was in the room where it happened and she knows exactly what occurred. She's the person most likely to give us a clear indication of what occurred. I mean, and now this hysteria of wanting to see the tapes, of wanting to see the transcripts. Well, I can give you both. Like, you don't have to hear a third party. You can hear it from me. Now, that's what I would be negotiating with. But, I mean, it's been shut down as a non-starter from Congress with not wanting to even have that conversation.
Right.
So then in the eyes of the court, I mean, I think it's a 50-50 ball for the judge to say, I don't have to. It's 100% the judge's discretion to release these. They can say, nope, I'm not going to do it. Thank you for requesting it. I don't even have to listen to Maxwell's team's argument. I am going to do a sua sponte on my own and reject it.
Real quick, Khalif, I know it's unfair to give this to you with such short time, but looking at what we saw reported from Bloomberg, the FBI redacting Trump's name before they handed the files over to the DOJ, how can the DOJ prosecute if the names aren't there?
It's problematic at best. That's what I can say. It's something that I would hate to be trying to do.
All right, this is to be continued on multiple levels, I'm sure, over the next few weeks. Khalif, thanks. Appreciate that. All right.
Queen City News Plus. Just search Queen City News on your smart TV's app store.